So I guess we'll get started. It's a little bit after noon. Welcome to everyone. Peter Harte circulated an email in December letting us know that he and I think 6 others had recently become qualified to engage in mediation, and telling us a little bit about the program. He I think sent that mainly to the defense bar. I don't know if he included the Crown, but it struck me that you did? All right, well, that's good. It struck me, though, that would be of interest to council, because mediation, at least speaking for myself, is an area that we haven't yet seen a lot of in the Northwest Territories. Of diversion, as far as I'm aware, hasn't very often involved a mediation process. So I thought to perhaps put on this seminar and ask Peter and Cait Ross and Kaitlyn, who I'll introduce in a minute in a little more detail, to come and speak to us, so we learn a little bit more about this option and where it might go and what's happening and how we make use of it. As usual, unfortunately, it's Crown prosecutors here, so I feel like I'm speaking to the PPSC. Thank you. Glad everybody came from the PPSC anyways, but you guys are the ones who are the gatekeepers. So I guess in that sense, it may be of as much use to you as it is to defense lawyers. The 3 people that are going to speak, I'll, in no particular order, I'll say a little bit about them. They've each given me a little bit of background. Cait Ross, who is sitting in the middle of the head of the table, is presently manager of community programs with the GNWT Department of Justice. She's been doing that for a year now, and will do it for another couple months, you said?
2 months.
2 months. And then she will go back to the Human Rights Commission, but even there, she specializes in restorative dispute resolution. Her background and training and education is in the area of international development, history, conflict analysis, and mediation. She also has over the course of her career done various work with local NGOs. Most of you probably will remember, or the older ones who've been around for a while will remember, she was a CWC in your office for a number of years, right?
You say 1 and 2.
Oh, just 2?
Years.
Okay.
Yeah.
And she wanted me to make sure that you knew she is now a member of the John Howard Society, which Yellowknife at least oversees the diversion program. Kaitlyn Butt, who's seated next to her, next to Cait, is the Community Justice Coordinator of Projects and Programs. She's been doing that for, he didn't tell me, I don't think.
I started in May of 22.
Oh, okay, so 5 years, or going on 5 years, or 3 years then.
3 years, yeah.
All right, and just recently has also taken on the role of community safety analyst, which she tells me involves sort of a broader overview, analyzing programs and assessing their effectiveness, or looking at new policy directions.
And like crime prevention activities within the community, things like that.
Kaitlyn was born and raised in Yellowknife. She loves working in the north. Her formal education is in the area of sociology and psychology, and is growing her education in the restorative justice area. She enjoys working with youth and creating second chances and steering people towards positive lifestyle choices. The third person who is going to speak, who we all know, they say he needs little introduction, is Peter Harte. And Peter, when I asked for some background information, said this. He said, Peter, and this is a direct quote, Peter was a lawyer for 35 years, 15 years in Ontario and 20 years in the North, and then he gave up. I can tell you, and I'm sure you'll all agree, that 2/3 of that is true. In terms of giving up, he did indeed retire from active practice. He tells me he finally, to me it seemed longer ago, but he tells me it was just last June. But in terms of giving up, I think we all know Peter well enough to say he doesn't give up. He was always very dedicated to the situations of his clients. In fact, more than just the legal situations, he would go out on a limb and try and help some of his clients find better housing arrangements, placements, supported living arrangements, that kind of thing. And the fact that he's back now and working with Restorative Justice, I think also attests to the fact that Peter hasn't yet given up. He's still trying to better the lives of other people and the people that end up in trouble with the law. So those are the three speakers who are going to explain to us today the changes and perhaps the advances we're making towards mediation as part of or an alternative in the diversion process. I just want to end by, and again, maybe this is most important and relevant to say to Crown prosecutors who are the gatekeepers, that I was reading yesterday a little bit about mediation. And when you, at least some of the studies have some pretty impressive figures. According to, there's a title, Restorative Justice. This is a report done by called Victims' Rights in Canada in the 21st Century. It's on the federal government website. According to this report, it says crime victims report being satisfied with victim offender mediation more than 80% of the time, and 9 out of 10 state they would recommend mediation to a friend. Looking at the traditional court process, victims report satisfaction rates of 42 to 79%. So on the one hand, 80% satisfaction when they're involved in the mediation process, and something as low as 42 up to 79% when they're involved only with the traditional court process. Again, victims indicated over 80% of the time they found the mediation process and any resulting agreements fair, compared to 37 to 56% of those who attended court processes. It's also, I think, worth noting, again, if there was a defense lawyer here, this would be more relevant, but even the offenders, I think, get something out of it. It often forces offenders to face directly the results on a personal basis of what they've done. And again, looking at something that the Corrections Service of Canada has put out, and this is mediation in a different context. This is mediation after being sentenced and while serving a sentence. But CSC is careful to say they can't say directly this is a result of mediation, but nonetheless, apparently 10 years after an initial meeting, 90% of inmates who participated in mediation and were released have not reoffended. So those are pretty interesting statistics, and I think personally show that mediation, at least in some cases, is something we should look into and follow up on. So with that said, I'm not going to talk anymore. I'll let you guys take it away. And
I should say at the outset, hopefully you won't mind if I don't talk to you, but I should say, and welcome to Judge McGee, because ultimately the judiciary will be mentioned along the way.
Please bring your friends next time. We're happy to have judges come too.
Charles, bring your friends.
Maybe this says how many friends I have.
At the outset, thanks to Charles for taking the initiative to set this up. It's great to have an opportunity to talk to people about this process and to discuss what kind of alternatives it offers us. I'm also glad that Trevor is here, because he and I had a real-life experience with this that was incredibly brief, but I think very effective. And I'll just chat briefly about that to give you a sense of what this process might involve. Trevor had a complainant come up to him and say that she didn't really want to testify in a matter scheduled for trial and for resolution, but she wanted to talk to the accused. Trevor came up to me and said, "What do you think?" And I said, "It sounds like a great idea." I didn't have time to prep my client other than to say quite literally, "Shut up and listen." And so the complainant, I think the offense had involved, he was trying to get his girlfriend, who had fallen down in the ditch, and unfortunately drinking was involved for both of them. The complainant's dog had come out and was barking, and she came to get her dog. And I think he said something like, "Get out of here, or I'll kill you and I'll kill your dog." And he had a 3.5, 4-page criminal record, so no stranger to the criminal justice system. But in the presence of Trevor and I, the two of them sat down, and The complainant, although, I mean, in the context, I'm going to be talking about this in due course, but in the context, she was really a victim and he was an offender. She talked about the impact of what had happened on her, that she and her daughter were afraid as a result of the threat that he'd made. They were concerned that the dog might get injured. And she talked about their history together, which involved her feeding him as a baby, changing his diapers, babysitting him. And I don't think it took 10 minutes before he was in tears. And I'm confident that in his 4-page criminal record, there were no offenses that involved crying as part of the end result. And he then spoke briefly 4 or 5 minutes, and the apology that he offered appeared to be genuine. He didn't appear to be a guy who would malinger in the sense of generating false tears. It appeared to be a situation where he was genuinely sorry for what had happened. I phoned the complainant or victim a few years later, about 3.5 years later, and asked her how she felt about what had taken place, and she said, and she'd had experience with the justice system before, both as an accused and a witness, and she said it was the best thing that had ever happened to her in court, that she still felt that she'd gotten a genuine apology, and at least as far as I was concerned, it was a perfect example of what restorative justice has to offer, and if you can call Trevor and I mediators in that situation, a perfect example of victim-offender mediation. I'll stop briefly and just mention terminology. The offender is required to take responsibility in some fashion for what took place, and so in that sense is no longer an accused. And since it's an apology that's being offered to a victim, and it's called victim-offender mediation, at that point, if the parties have agreed to engage in restorative justice and some form of mediation, the victim becomes a victim as opposed to simply a complainant. By way of quick background, this appears in Canada to have been kicked off by a situation that arose in a community called Hollow Water. It's a Manitoba Ojibwe community, and there's an extensive discussion of what took place on the Canada Justice website. It's 20 pages of background talking about how this situation arose, how it was dealt with. But in a nutshell, it was a community that involved generations of sexual abuse, and they ultimately decided that the problem was too big to be dealt with by the criminal justice system, amongst other things, because they would have witnesses who were themselves accused testifying about what had happened to them. And quite literally, it was a situation where abusers were victims themselves, and it was decided that it was effectively impossible to deal with this in the formal justice system. And so they developed a circle healing process where victims and offenders sat down and talked what had happened, talked about what had happened to them, how they ended up in the situation that they were in, and worked on recovering from what had happened. There's also a National Film Board brief video on this where a man and a woman who were both abusers talked about their participation in the process and what they ultimately got out of it. I'm not sure if that situation was the impetus for this, but Section 17 dealing with alternative measures became part of the criminal code in 1996. It was not until 2010 that the NWT diversion protocol came into being. Oh, and I should say I've copied the new Deskbook provisions dealing with alternative measures, but if I reference any other document that you want a copy of, send me an email and I'll make it available. In any event, it was not until 2010 that the NWT diversion protocol came into being. It's signed by the PPSC, the RCMP, and Community Justice.
Minister of Justice.
Minister of Justice, thank you. It is relatively limited, and I'm sure we've all had to deal with this one way or another. It talks about what's subject to diversion, so all territorial offenses, summary conviction offenses, hybrid offenses where the prosecution proceeds summarily, minor breaking and entering offenses where the loss is minimal, other offenses if the RCMP and community agree and receive written consent of the Chief Federal Prosecutor. The last provision has been dramatically altered by the new Deskbook policy, which I'll come to in a moment. But the protocol provides that offenses not subject to diversion include family violence matters, including spousal violence, except where the prosecution chooses to divert a matter. Criminal code offenses where a weapon was used or threatened to be used, offenses of a sexual nature. And as I say, the new PPSC Deskbook policy on alternative measures expands significantly the offenses for which alternative measures are potentially available. And just, I think that's captured by a brief excerpt from the Deskbook, which says, as said in the introduction of this guideline, the law does not limit the types of offenses that can be dealt with by alternative measures. Therefore, all offenses are eligible for alternative measures. Alternative measures is sort of a subset of restorative justice. And Nova Scotia has an incredible restorative justice process. And you may have read that a murder in Nova Scotia was referred to their restorative justice program. The judge had imposed a sentence, but felt that it was appropriate. And just by way of a quick background, the protocol in Nova Scotia, I think it's like 30 pages long, and it specifically provides that the judiciary can make referrals to the restorative justice process. And in this instance, the judge indicated that it was not going to have any effect on the sentence, but may affect at the end of the day the offender's eligibility for parole. I think it was a second-degree murder. And the bottom line is the judge was clear that this isn't a way to help somebody escape a penalty, which is why he'd imposed the sentence before he referred it for a restorative process. At the time he made the referral, it was not clear whether the victims or family of the deceased were going to, I say victims, I'm referring to people affected by what took place, whether they were going to participate or not. But the bottom line is the judge made that referral, and it was a first in Canada with respect to the seriousness of the offense. In terms of what prompted my correspondence with defense counsel, one of whom is here, the Community Justice put on a victim offender mediation program in October, and that was, I think, the initiative of Cait and Kaitlyn, am I correct in that? And it was a pretty intensive 3 days that we discussed what can happen in victim offender mediation, and I wanted to make clear that it was available as something that could be taken advantage of, either in terms of being dealt with according to a diversion paradigm or as part of a regular criminal prosecution where the result of the offender demonstrating some real remorse would be taken into account at the end of the day. So the Crown doesn't necessarily in this situation need to commit to a particular sentence or withdrawing or staying a charge at the end of victim offender mediation. The Crown would, in terms of agreeing to deal with it in this way, the Crown would simply agree to amend slightly any no contact provisions in the release order and consent to the matter being dealt with by a justice committee. In terms of moving forward with this, the Crown has been very cooperative, and this is written down already. I didn't put that in just because I saw you guys here. The Crown has been very cooperative, and one of the things that was clear when I started working with the Justice Committee at the John Howard Society is their lack of knowledge of the criminal justice system meant that they weren't clear about what kind of documentation could be available in connection with a criminal prosecution. So I wrote Jill and asked if it would be possible to get general reports and potentially video, and she agreed immediately that that was not a problem. And so the Justice Committee at the John Howard Society now gets more information. They thought they were restricted to the PIS only, but they're now in a position to make decisions about what should happen with diversions, or really any matter that comes before them for purposes of restorative justice with more information than they had previously. That's not due to me, it's simply due to what any criminal lawyer would have been able to provide them with by way of background information. I also met, FISA is the executive director of the John Howard Society, and we went and met with one of the watches at the RCMP detachment, and I'm in the process, the guy I need to deal with is back on the 23rd, but I'm going to make arrangements to deal with the other 3 watches. And we've committed, one of the problems with the police diversion is that stuff ends up in limbo, and the police who make the referral have no clue what's happened or whether anything has happened. And so we committed in our presentation to them to getting back to them with an update within 10 days of the referral. And my impression from the leadership is that they support alternative measures and diversion where it makes sense to do that. Ultimately, in my discussion with the watch that I met with, I put to them, it is your call as to whether you think it's going to be effective in the situation, but anybody who you think should be coming to the Justice Committee will take. The difference between diversion and alternative measures or restorative justice is that diversion in the model that's used in the NWT means that people are diverted effectively from the justice system, and if they're successful, that ends the matter. It's typically withdrawn. Whereas alternative measures, as referenced in the Deskbook policy of the PPSC, do not necessarily involve the charge going away. They don't necessarily involve a stay or withdrawal, and the PPSC policy with respect to this contemplates stay or withdrawal, and typically, as I say, with diversion, the matter is withdrawn at the conclusion of a successful diversion, and now it's available as something that can be taken into account without the Crown committing to a specific provision or a specific disposition, where an accused and a victim or victims sit down and discuss what's taken place, or the accused engages in restorative justice of any kind. The Crown can simply take that into account. And I've, in my speaking to people about this possibility, have said that I can guarantee you that the court is going to take this into account one way or another. It's not going to be an exercise which is a waste of time, even at the end of the day if you're looking at jail. It may be that you end up with a conditional sentence order instead of institutional jail. The bottom line is that I guarantee you that the court will take this into account in some fashion. And by way of just a quick introduction to the criminal code, I'm sure you're all familiar with this, but the critical variable, apart from the Crown agreeing to make the referral, is that the accused who becomes an offender has to take responsibility for what's taken place. The language in the code is carefully chosen. They're not looking for an admission of guilt. They're looking for accepting responsibility for what took place. And so potentially an accountability component would be, I got drunk and then I was stupid and I'm not really too sure about what happened, but I agree that it happened because I was intoxicated at the time. And those are situations where nothing would stop a victim offender mediation from taking place. It would just be that the offender is not in a position to accept all of the responsibility that might be associated with what happened. However, to the extent that we're dealing with an offender with a limited recall of what's taken place, he or she will hear firsthand from the person who was directly affected by it what that person recalls about what's taken place, and the expectation is that the discussion associated with the mediation will mean at the end of the day that the offender is prepared to acknowledge that everything that resulted in the charges in fact is a fact associated with the charges. There was one of the things that we saw in the training that we engaged in with respect to victim offender mediation was a situation where a single individual had been bullied at school, and the individuals who ultimately attended for the mediation session, which took place in a circle. And typically victim offender mediation, just in terms of the geography, would take place in a circle, although there's no reason that victims who are reluctant to engage directly would not be able to attend remotely. And last night we had a 3-hour victim offender mediation, and the victim attended by telephone for about 10 minutes. He had some cognitive difficulties that would have interfered with him participating fully, but it was possible for him to attend by telephone. And the victim offender mediation process is one that offers flexibility so that the attendance of the victim can be by any means remote, telephone, or sitting in another room by video, that the opportunity to have a discussion is not limited to something that takes place physically, face to face. The bottom line really is the process is intended to create accountability on the part of offenders. And I'm confident that I can say on hundreds of occasions the people in this room have heard an offender say what people at NFCC told him, typically him, to say, "I'm sorry for wasting the time of the court." And obviously that doesn't involve any real accountability, and in some instances there's never any interaction between an offender and the people ultimately who deserve the apology. The lawyer, it's just the way the system works, the lawyer does all the talking for the accused, and there's never any real accountability, which is why, as I say, the fundamental premise is direct accountability for what took place. Another goal of the John Howard Society, I mentioned that we were committed to a 10-day turnaround for police referrals, is to develop some serious credibility. That's the reason that we've reached out to the police. That's the reason that we have told them that we'd get back to them in 10 days. The system has resulted previously in stuff ending up in limbo. There's a file that the John Howard Society has that began last spring, and because of illness and some changing faces, it's not been possible to deal with what was ultimately, I suspect, unsuccessful restorative justice approach, because 2 of the offenders were prepared to do it, the other 3 weren't, and it's so long now that it will be almost impossible to pursue it. So right now the process at the John Howard Society is, and these obviously involve Yellowknife matters, or matters where the offender has ended up in Yellowknife, the referral takes place in docket court, always on a Tuesday or potentially a Monday, but typically Tuesday. The John Howard Society then has its meeting, the intake takes place as soon as possible after that Tuesday. So FISA makes arrangements to meet with offenders later in the week. She then puts together a package for the Justice Committee to review Tuesday evening. We come up with a tentative plan for how we're going to deal with the situation, and that plan involves, for example, what might be done by way of community service, and all of this, as I say, is an attempt to have the accused take responsibility, or the offender take responsibility for what's taken place. So community service would be something that is involved in that. One of the things that has been a bit of a barrier is people who find themselves in the criminal justice system is how that community service can get dealt with. And we're going to talk briefly or momentarily about how long these kinds of processes take place. And one of the things that stalls them is the inability of the offender to get community service done. So I was dealing with a fellow in docket court. I was there as FISA's substitute because she's on vacation. And he indicated that he'd not been able to do snow shoveling for elders, and how that got identified as something he should do by way of community service, I have no clue. But at the end of the day, we were able to find an alternative for him because, as I say, asking offenders to do their own, make their own arrangements for community service ends up being a real barrier for them to move forward. What we want to achieve, as I say, is credibility, and we think that we're able to do that, or will be able to do that, by the speed of the response. So just to come back to the timeline, intake is Tuesday, docket court, or we get it from the police and get back to them in 10 days. But intake happens after docket court. The committee meets the following Tuesday, and then, if we can set it up, meets with the offender the Tuesday after that, so that the idea is to move things forward as quickly as possible. In that regard, the Crown, as I say, has been cooperative, and their decision to have continuity with respect to circuit assignments will assist with that, because the hope is that on circuit, the same kind of timeline can be set up, so that if individuals are coming to court with the possibility of a matter being dealt with by way of restorative justice, the Crown will have already indicated that on the file before it goes to defense counsel, so defense counsel can meet immediately with the potentially the complainant, but more importantly the offender, at that first circuit and move things forward as quickly as possible. We've all had situations, and we're going to talk about capacity, but we've all had situations where we show up on circuit and learn that the justice coordinator has moved on to a full-time job, or is on vacation, or for whatever reason has not been able to complete the restorative justice process that's been contemplated. And the idea of making it happen sooner will hopefully eliminate that. Another thing that we hope will eliminate that problem is creating a model that we can export using what we've been doing at the John Howard Society, that will be easier to put in place in other communities. And amongst other things, what's been discussed is increasing the capacity of the local justice committees by having individuals go and train them with respect to file management, with respect to how the court process, that in many instances they don't understand, can be tied into what they're doing, what the Crown does, what the defense does, so that people who are running the justice committees have a better sense of how the system works and what their interaction with the system will do for them. So that, Charles asked a number of very helpful questions, so that answers your first question, Charles. And more important than anything else, to the extent that information is available to the Justice Committee, in particular in Yellowknife, because there's a lot of capacity there. FISA is doing a great job of getting back to people with respect to the progress that offenders are making. The faster that that information can end up in her hands, the faster we can do intake, and the faster we can ultimately move the restorative process along. Another question that Charles asked was, how long will the process take? From the 3-week start to finish, although it's not an actual finish date, the process can have a timeline that I've just mentioned. With respect to the offender completing the contract, because what happens at the end of the meeting where the restorative process is discussed is the terms that people have agreed will be satisfied by the offender are reduced to a contract, the offender signs off on it, and the amount of time that will be taken to complete that depends on the terms of the contract. So, for example, I was dealing with a fellow in court, picked up the file from FISA, who had been asked to attend 6 counseling sessions and bring proof of attendance, and 6 AA meetings. And that obviously would take several weeks to complete, because he's got to make arrangements to get into counseling, he's got to find an AA group to attend. So that, as an example, was contemplated to take place over the course of about 6 weeks. We had a mediation which was chaired by Cait last night, and 3 of the Justice Committee members were there, and it took 3 hours. But because of the nature of the process, we weren't able to discuss with the offender exactly how long it was going to take to complete things. We, in essence, just to give you a sense of the breadth of the kind of contract that can be produced by this situation, he's required, I'm not going to tell you who it is, but he's required to get a computer this week to start making arrangements to do remote school. Next week he has to go to Aurora College and find out what kind of a program he's going to need to take to complete his GED. The following week, while he's at Aurora College, he has to go to the Tree of Peace and make arrangements for counseling. And then we weren't entirely clear about this is a very dysfunctional family, what level of counseling would be required to get him up and running in terms of being able to deal with the dysfunction. But it's going to be a situation where he comes back and meets with the Justice Committee, figures out what he needs to do to move forward. So in that situation, in a more complex situation, it's going to involve some time, and it may not be possible to put a timeline on it. In this instance, just to give you a sense of the level of seriousness associated with this offense, the offender had ended up with a baseball bat. The victim had supplied the bat, unfortunately, and mom was involved, and there was bat swing going on. The offender ended up taking a BB gun and shooting the victim with it, leaving holes that the police could see. It sounds like the bat did more damage than the BB gun, but in any event, it obviously could have done significant damage, and it was nevertheless, and I'd like to find out who did this, it was nevertheless referred to the Justice Committee, but it worked out beautifully. The accused or offender, I think, was very responsive to our conversation, appeared to be genuinely remorseful, and was able to interact with us in terms of putting together a plan to help him go forward and eliminate some of the problems that might be associated with his dysfunctional family. But to come back to where I started and answering Charles' question, it's impossible to say exactly how long that will take. Charles' next question is who would actually be involved? Critically, the offender has to be involved, but in the situation that we dealt with last night, he attended with a family member, and in the normal course, we would expect an offender to have some kind of support with him or her, typically her, but it's sort of, not only is it critical that the offender be there, but it's critical to the process that the offender be in a position to interact with what's going on in a way that's comfortable, otherwise the process won't work. It has to be open, it has to be transparent, there has to be accountability, and if the offender doesn't show up with an appropriate mindset, it's just not going to work. And in fact, I flunked somebody out, so to speak, last Tuesday because there was an attitude problem, and I just didn't think that the person was going to be able to participate. Family support or a friend is critical to helping the offender not become super defensive about what's going on. Obviously, as well, to the extent that we can make it happen, it's critical that the victim show up. It may be that we need a substitute for the victim, and so a family member might show up, but at the end of the day, there has to be somebody there in respect of whom some kind of accountability will take place. And if it ends up being a situation, we were able to get the offender last night to attend by phone, but if the victim, if there's no kind of direct interpersonal accountability, it's not going to work. So we need a victim or an appropriate substitute for the victim. The others who are going to attend are the mediator, and as I said, Cait, who has the most experience with mediation. She was doing that work for the Human Rights Commission here. So she led the session, but we had 3 other members there who were effectively learning how to deal with this, because we want to be consistent in the approach, and the hope is that we're going to get more referrals. And so what we want to ultimately be able to do, and I have to thank Cait for this, we want to be efficient And so in terms of moving forward as quickly as possible, rather than just meeting on Tuesdays, if we can put teams together to do this more frequently and through the week, the idea is that we'll be able to do more work, but it's critical that everybody be on the same page. The other members of the Justice Committee, for personal reasons, were not able to attend the Victim Offender Mediation program, so it's a situation where they're going to be learning on the ground. And we're also going to have a planning meeting, is it for the 6th? I think the 6th of March, which will allow us to discuss this and make sure that we're all on the same page and moving forward basically with as much consistency as we can arrange. The next question that Charles asked, and thank you for the organization, that was very helpful. The next question that Charles asked is, what is the step-by-step process of getting a mediation process going? And so in a nutshell, I think it starts with, if the Crown has not already suggested that it could be referred, the start from the defense perspective is to ask the Crown to make that referral. Specifically, it does not require a commitment from the Crown. It can absolutely be a wait-and-see situation where the results dictate the position that the Crown ultimately takes. But as I say, I've guaranteed to people who I've spoken to about this, at the end of the day, with respect to disposition, and hopefully any judges don't take exception to this, I have said, I can guarantee you that it will make a difference at the end of the day. How will success be measured? Ultimately, it ends up being a pretty straightforward situation. If the offender satisfies the terms of the contract, that's success. However, it may be that we need an additional meeting. So to come to that conclusion, one of the fellows I was dealing with in court on Tuesday was supposed to, the 6 attendances at AA and the 6 attendances for counseling. However, he didn't do that, but he went to the WMS program at the Salvation Army, completed phase 1, didn't complete phase 2 because he sort of trailed off towards the end of it. But the woman who was in charge of monitoring the program said that he had done well while he was there. She thought that he had gone to counseling in addition to what he was doing at the Salvation Army, but as far as she was concerned, he had done a great job in the program and had been there for 2 weeks for phase 1 and then another 6 weeks for phase 2, and so had been involved in a effectively AA process from 9:30 to 12, 5 days a week. She told me that he didn't miss any meetings, and so the committee is going to have to get together and, just for the purpose of putting it to bed properly, agree that he's completed the terms of the contract, but that in terms of process and timing means that it's going to take more time to make that adjustment to his contract. I suspect the committee will have no difficulty with the proposition that he's done more than they initially asked in the contract. What communities will a mediation process be possible in? For the moment, formally, only Yellowknife. However, as an example of what might take place elsewhere, there is a minor sex assault involving an elder in Delaunay, and Robert Firth, who is a very experienced Justice Committee chair in Liard, is going to be traveling to Delaunay. For one reason or another, planes getting weathered out, going mechanical, etc. It's not moved forward as quickly as would be optimal, but he's going to go there and have a victim offender mediation session to conclude the matter, rather than have this elder, for what amounts to a relatively minor offense, go through the formal justice system.
Peter, I'm going to need to interject just because I want to make sure, like, we don't have a ton of time left, and I do just want to make sure that things are clear. Robert Firth is actually, he's a huge asset. He's been in Fort Liard for some time, tons of experience. He's actually looking to retire. He actually came out of retirement to work for the Hamlet to do this work. So the other thing I want to mention is it's not just Robert. So Peter, we were lucky enough to have Peter join the John Howard Society board, and then we did organize to have another victim offender conferencing training in Yellowknife, and it was open to all of our coordinators to attend. 2 years previous to that, at our annual symposium, which some of you were able to attend this year, Chief Judge Scott also was able to attend for part of it. So at that same event 2 years ago, that training was provided to all of our community justice programs. So I think where the crux of the issue comes is that as I think a lot of you are familiar, our justice coordinators have high turnover. So we're not always capturing, but I guess I just want to interject that there are some stronger communities that are doing victim offender conferencing. I would say Inuvik, Fort Smith, this is also, some of it is the nature of living in the north. Our coordinator in Fort Smith lost her husband in that tragic plane crash and was out of the office for an extended period of time. She's now back, and we're really lucky to have her back. She's doing victim offender conferencing. What are some of the, Lidley Fort Simpson has a really active community, and Alexis Fox is a really proficient victim offender mediator. Robert Firth is a good example. Delaney specifically has a new coordinator who's just come in under Delaney Gauthier government. He has lived experience, and the idea of this Delaney file was to have Robert Firth fly into Delaney, do the diversion, the victim offender conferencing with the new coordinator to build local capacity. And as you've referenced, nature of working in the north, that community, that accused, who is an elder, lost his daughters suddenly, tragically. So that, this gets postponed, and then weather, and then I'm actually not even sure, just to be frank, because I don't know who referred that. I'm not even sure that is actually going to resolve, because it has been pushed back so frequently. So it's unfortunate. I hate to come here and tell people that our service provision isn't across, it's not the same across the NWT, and that is a huge barrier that our department, our division is aware of. But I did want to jump in because there are, Peter's here also, and I've also joined the John Howard Society, so I think I would love to come back when I'm out of this role as the manager of the program and just as a committee member, and we can talk maybe more about the headway that we've made as a committee in terms of organizing our processes and things like that. But as in my current role, I do want to make it clear that across the NWT there are other active committees, and the reality is for some of you who've been practicing in the north for a long time, you'll be aware, you get a great coordinator who's really self-motivated, who has some context of the criminal justice system, and they do wonderful work, and then they move on to different work.
I just wanted to ask pretty basic questions to make sure that I've understood this rightly, where mediation seems to be something that is different from a normal diversion referral. So I would ask for mediation from the community justice where I felt I had an appropriate file and it seemed more serious than what I would normally refer, and then the mediation program seems to have what would be a diversion plan built around the mediation component. Have I got all that right?
No. So I think this is another thing that I think is confusing, and I hate to be nitty-gritty, but about as a trained mediator and as a restorative dispute resolution facilitator, they're different. And I think you're all lawyers, so mediation is very specific, and you can be trained in different styles. And what we actually don't refer to diversion as mediation. What you're going to see in a lot of the communities is the language they refer to it is a diversion. The other thing too, and Kaitlyn, feel free to jump in, is that our model is community-based. So we fund the programs to different local host organizations, as I think a lot of you know. What that community does in terms of their programming, yes, their funding requirements are to provide diversions, which in like Uluhaktuk, there might be 2 a year. In Yellowknife, there's going to be hopefully more. And crime prevention activities. So you might find, and part of this community-based model is to ensure that what's happening in Fort Simpson, the diversion method that they use, their restorative method, is going to be developed locally by their community and informed by culturally relevant practice. So I would never, I personally, and we don't use the language of mediation in our work, and certainly not with our coordinators. Some of the training that like Peter and well, all 3 of us were at, and some of the other coordinators have had access to, is the victim offender mediation. Victim offender conferencing is a term. So I mean, I hate to be nitpicky about the terminology, but I just think when you're interfacing with our community justice coordinators, I think if you say like, oh, you're going to do a mediation, I think that's going to be like, no, actually we can do a diversion that is hopefully founded in our training that has been provided, as well as tailored to what is culturally appropriate to their community.
Yeah, I guess like when I refer something for diversion, my understanding is that the Community Justice Council will craft a plan that they feel is appropriate, and when they're done, they tell me diversion was completed. I say, great, I don't look behind that, and we withdraw the charge. And so what I've understood is that there's another pathway here, or it's all part of diversion, and the end result is withdraw the charge.
I think what we're looking to do, if I may, this is so confusing, but as a John Howard Society member, Levi, like I think what we are looking to do is build capacity locally within the John Howard Society to be able to go beyond diversion.
But that's not a thing yet.
No.
Mediation is just a richer set of tools that's available in some of the CJCs.
What I would say is this is like by virtue of Peter Harte joining the John Howard Committee and myself joining the John Howard Committee, we are going to be ramping that up and making attempts to move in that direction. You heard, I guess, the facts of the victim offender conference we did yesterday that were, more serious in nature. Like when there's assault with a weapon, those aren't files we're typically, and I think a lot of the other committee members didn't want to take that on because we're not able to handle those kind of situations. So I think, and I'm not trying to sit here boasting, but I think with the 2 of us joining, and we're going to hopefully, build some capacity within the John Howard Society, so the local Yellowknife program. But that's certainly not the expectation of other communities. And I understand that it's now in the PPSC Deskbook that you folks are really expanding your ability to move towards alternative measures. I think that's wonderful. I think in reality, the capacity across the Northwest Territories to handle more complex situations, is going to ebb and flow and is going to differ from community to community. What I would recommend, and Kaitlyn, feel free to jump in, what I would recommend is, I understand PPSC is now, you have a Crown and a Crown Witness Coordinator assigned to each community for the year. My recommendation is work locally with your coordinator, get a sense of what their committee is like, what their capacity is like, and speak with them about potential alternative measures on a more local basis. but I just don't think you're gonna get that everywhere.
Yeah, so I was just gonna put in there that I think it's important to note that our office sees that the desk book is changing, and across the board, we would like to see these changes that John Howard is striving for. So in the future, I hope to be able to say this is across the territory, and I hope that we're making strides in the right direction. Even in like a diversion, the victim should be involved, so there should be some sort of mediation type relationship in there. But these are all shoulds that I'm gonna say. So like Cait saying, there are differences between committees and different communities. However, our goal and what we're training for and striving for is that cohesiveness.
Allison, you had a question.
I did. So my understanding before was that, like, if there's a situation where there's a conflict in a community or the community justice isn't active, that we can reach out to Restorative Justice and there can be support from other community justice groups.
And but just to clarify, but Restorative Justice at gov.nt.ca, because that's going to come to both the coordinator and the manager. Because the other thing, just to add confusion, is Maggie, whose mat leave I'm covering, is back in 2 months. So regardless of who's in the position, it's going to come to the coordinator, it's going to come to the manager. So yeah, if you have trouble with any of those, that's where you would reach out.
And so with that understanding, it's still possible or feasible for us to reach out if we have a complex matter that we know the Community Justice Committee in that location wouldn't be able to handle. That's still something that...
Yeah,
100%.
Okay.
So like questions, concerns, ifs, ands, buts, by all means reach out to us in any way, shape, or form. Even if you're like, this is a far stretch, this is like a 2% chance a committee's actually going to take this on anywhere in the territory, reach out anyways, because it's something that there might be something in the works already.
I didn't realize how time was going to be ticking by, but Kaitlyn also deserves some significant credit in terms of dealing with capacity and credibility for the program because basically she said, if you've got a problem, send me an email, and then she will follow up with the local justice committee. So if there's a report missing or a specific project that you think might be necessary, she's the one to speak to in terms of setting that up. And the reason I referenced Delaney and Robert Firth is just as an example of something that falls outside the ability of a local justice committee to make it happen, and so community justice is arranging for somebody to go in to make that happen.
it does come with such complications, as like you're aware, that like I can't sit here and guarantee you we're going to be able to, in every situation you think there's going to be an appropriate diversion or alternative measure, I can't guarantee that we're going to be able to fly a trained facilitator in to assist, but I guess if you take nothing else away from this, it is to reach out to our division, our office, if you have questions, concerns, or want to run like files by us. Is it Trevor? Did you have a question?
No, it's fine. Follow up with Peter right there.
One other thing that and it sort of flows from Levi's question, if you don't mind me pointing to you behind me. One of the things that I suggested in my correspondence with Jill was that it would be helpful if the Crown provided a recommendation with respect to what issues they see in the file. That might assist whoever it is locally to deal with it. And it also gives, if it comes to the John Howard Society, it also gives us an idea of what the Crown's looking for out of the process. Because more than anything else, we're looking to establish credibility. And so being able to respond to the concerns that are referenced helps us in terms of the mediation process.
I think flagging the issues is certainly important from your folks' perspective. What I do want to be careful is, because I have heard that this has happened recently in a few communities, is you cannot bind an outcome of a referral to diversion. So I have heard there anecdotally been a case where in in court, somebody did say, like, I think it was like, we will make sure community service hours, or it was something a bit more specific than that. I can't remember the details. And it's like, when you divert or send something to the Community Justice Committee, certainly flag the issues. In terms of the outcomes, those are to the committee. And that's something else I do want to flag, certainly on the John Howard level of things, but also in the communities. We are talking about widening the breadth of outcomes. And I also wanted to talk about that in relation to accountability. Accountability takes time. Part of that can be meeting with the facilitator, meeting with committee members, meeting with the victim ideally, and also with the outcomes that are agreed to as a result of your victim offender mediation. So I think accountability is a process. And I think demonstrating accountability is an apology is a piece of that, but also finishing what is agreed to in your contract is also demonstrates accountability. There was something, another thing I just want to say while I have everybody, or people still here, is my plug for Rupert Ross's books. He is a retired Crown prosecutor out of Ontario. He has 3 books, and he references, actually that's how I first heard about Hollow Water, that case study. But in my humble opinion, PPSC, I think that should be for anybody practicing law in the Northwest Territories. I think those 3 books are foundational knowledge. So that's just a personal plug in there.
I have a question. I find there's a lot of ideas. I think Crown is prepared to move forward in that direction as well. I don't hear about investment and to make the process work, because as many books as we read, I think most of us have read those books, there has to be something for us to be able to implement those things. And so I'm not hearing that something is being done right now. Am I wrong? Or?
Well, at the John Howard Society, it's certainly happening. I mean, we're making an explicit effort to do, critical to mediation is involving a victim or an appropriate substitute. Otherwise, there's nothing to mediate. And so diversion or some form of alternative measures can take place without a complainant, but mediation can't. So so in terms of the mediation that took place, we had the agreement of our victim to participate, but then, as I say, there were some cognitive issues, and he ended up attending by phone. But that component is critical, and I think we're speaking particularly Cait and I expect the other members in due course, are going to be able to involve victims to a greater extent than was previously the case. And so in terms of a referral, I think we're in a position to make that happen.
Yes, Angie, I think am I understanding you're asking about investments like territorially?
Yeah,
not
in terms of knowing what we can talk about with victims, because we do have often victims talking about like what they would like to do.
Yeah.
And what I heard is that mediation aspect can be done at the same time as the criminal, and which is very appealing for a lot of cases we're dealing with, and more serious cases maybe as well. But I mean, I'm not going to start talking about it if that's something we cannot do right now, or if it's something we can only do in Yellowknife, for example, as opposed to other communities. What is realistic? So that's more what, like, are we aiming for being able to do that?
I certainly think I think making false promises to victims is dangerous for many reasons, and so I hear you. I think that with your changes to having a consistent prosecutor and Crown Witness Coordinator going into each community, what I would urge you to do, and what we're pushing on our end, is make a relationship with that local coordinator, that local committee, see what their capacity is. And I get that you guys don't always have time, you're in and out quick, but when you return to town, continue those conversations to see what is feasible, because what's the word I'm looking for? We do not have an across-the-board equal service provision. So what I guess we can sit here and say to you is that in Yellowknife, through the John Howard Society, we're working towards that. I can't speak for the other communities. It varies so significantly, as you well know, and we've talked about. But I would encourage, with the continuity from your office, to engage locally. And if you have any problems or you're not sure who it is, like, reach out to us. I think we just sent an updated contact list, but we're happy to assist in facilitating those conversations, because the other thing is, Kaitlyn, as the coordinator, she's the direct relationship with the local coordinators and the committees. So unfortunately, I think the answer to that is it depends which community you're in, and it really depends on and having those conversations with the local committee and seeing what they have, what they're able to provide.
Nothing stops you, provided the participants are prepared to have that happen. Nothing stops you from attending the meeting. I invited the members of the watch who I spoke to, show up, not with guns, but like on an assault PO, show up, get a direct apology, some kind of direct accountability face-to-face with the individual who created the problem. Nothing stops that from happening. As long as the group is prepared to see that happen, nothing stops it. And the other thing is our ED hands out PISs and now general reports, and then she collects them all at the end of the meeting, so the information is protected. And everybody agrees that what the discussions are confidential. I needed to give you some examples, but I didn't name any names, obviously. The discussions are confidential, so nothing would stop you from saying, I've got this situation, do you think you'd be in a position to deal with it? And we circulate that email and discuss it so that you get a proper response from at least the John Howard Society, and nothing would stop you from doing that with Kaitlyn as well, because she'd be able then to reach out and see who would be able to satisfy whatever it is you're looking for.
And doing that prior to like notifying the victim, like this is a possibility. You wouldn't want to do that for sure, but reach out to Kaitlyn, reach out to the local community, what is possible, and then take that back to the victim and say, hey, look, this is generally what they offer. Are you willing to, I've spoken to them, are you willing to meet with them or meet with the coordinator to better understand what a process could look like in this situation?
So if I understand correctly, it's a bit like what we've done for sexual violence violence. We just contact you directly before talking with victims, or when we think that mediation might be something that would be appropriate, and then you tell us whether it's possible or not, and then we can.
Yeah, I think maybe having Kaitlyn and the local coordinator all involved in that conversation.
And like, I know a couple other cases too, like where we've had referrals come in and there's no active committee in that.
Mm-hmm.
Like in that case, they would come directly to me and I can do the search around to see who's available and who's able to take on cases too.
From a different community.
Yeah, so I think the safest, easiest option is for you to reach out to me directly and I can bring in communities. If you have a relationship with that coordinator already, by all means, feel free to reach out to them directly and CC me. Like, whatever you think works best for the community that you are working with and the case that you're dealing with, too.
So I would say, Angie, like in concise terms, the gold standard is reach out directly to that coordinator if you know that person, and include Kaitlyn in that, or Restorative Justice at gov.nt.ca, so that we have a couple eyes on it and we can have like a conversation about it, so that Kaitlyn can assist. Anyway, all of the so that you have a few different eyes on it. And then Kaitlyn can organize if they feel like it's beyond their capacity. Then Kaitlyn can look to other communities and other coordinators that may be willing to do that. In Yellowknife, I would say reach out to FISA directly. I mean, CC Kaitlyn all the time. And something that Jill and I had also talked about is with intimate partner violence diversions. I think the process we sussed out is that all intimate partner violence files are going to be going to IPVTO. We are not risk assessment, intimate partner violence risk assessment specialists, so we've asked that all IPVTO files go to IPVTO. And so Janine they'll review the files, they'll come back to PPSC and make a recommendation of like, I think these two files could be suitable or are more suitable for diversion.
If they're too like low risk for the
Yeah.
program, like we see that sometimes in intimate partner violence, that a file is too low to be in the program,
Yeah.
so we can look at alternate mechanisms for having that extra piece or the special piece.
So that's a perfect example of where mediation would be critical, because that's not necessarily part of the Janine's program.
No, it's not.
But I do want her eyes on it first, because we did get a higher risk file referred to us, and I was like, Jean, can you look at this? Like, I don't think this is appropriate, but like, please look at it and tell me if I am. And she looked at it and she's like, no, that is somebody who would be more appropriate in our program. And that's kind of how we came to this process.
Conversation.
Yeah, is that we would like to see, especially at John Howard, more IPV, well, not that we would like to see them, but we'd like to see referrals for lower level intimate partner violence cases, but wanting to make sure that IPVTO is vetting and has their eyes on it, because they're more proficient with the risk assessment and determining what's appropriate and what would be more appropriate in their program, and then what could be more appropriate to come to us.
Yeah.
Something that would be really valuable is to have a list of what you do. So it's like, here's what we ask the offenders to do, because I think that there's a lot of people who may not know exactly what is part of the contract that we talked about a lot here. And, you know, is it a letter of apology? Is there a community service there? What is your laundry list of things that you pull from that are things that you have people to do? Because you're asking people to comment on what they should be doing or what the crowd feels that they should be doing, then they don't know what they don't know.
Sorry, I think to clarify, we're open to comments from the Crown on the issues you see as being part of the file. Outcomes are to the committee. And I'm
not talking outcomes, though. I'm talking like, you know, an issue is, you know, the victim needs some closure here, so that might be a letter of apology or something like that.
Or a victim offender conference.
Yeah, there's really
Or like language too.
no limit
Yeah.
on what can happen. I
Sure,
mentioned that.
and that's fine, but you know, some people need something to refer to.
I think
and
we
something
can
understanding.
definitely put together a list of like the cookie cutter sanctions or outcomes, and with the caveat that committee by committee, occasion by occasion, it could be different. We can expand on it. Could be tea with an elder instead of going to an actual counselor. Like it can fluctuate, but we can absolutely put together like our cookie cutter outcomes.
Because
for
people, if they're talking to victims, they don't, like, until they then go talk to you, or they don't know what's happening either. And so if somebody asks Berthier and says, you know, what's going to happen here?
Yeah.
And you're like, well, you're going to have to talk to these people.
Yeah.
That's not going to help the victim.
I think what's important, like in true restorative fashion, and this is what I'll be pushing for with the John Howard Society, is it's a very tailored approach. So, for me, I guess I'm going to speak frankly, I'm sick of hearing community hours, and I'm not trying to be flippant that those aren't valuable. In some situations they are. I actually don't think it's specific enough. And I think also my concern about sending, like, we can send outcomes for sure, examples of what outcomes are. In last night's victim offender mediation, the outcomes, the first segment of outcomes, the first month of what his to-do plan is, might not look to you guys like it correlates to the offense that he's there for. But I mean, yeah, I think it varies so significantly that that I think there's a couple, I just see some issues with that, but we can send you a cookie cutter of what could happen from it. I think in like the incident that you're, or the example you're using, like Angie, you're gonna refer somebody and a victim asks like what can come out of that. I would say, you know, speak to the committee. We're not throwing people in a room together. It's not like, oh, great, you're here, you're gonna get in a room together. There's prep. There's prep with just the facilitator, just the coordinator. So there is gonna be a conversation of like, what outcomes do you think are appropriate for this? Can we engage victim services? Do you have a support person to gauge what the victim herself, himself wants to see as accountability, as the outcomes, and then have that conversation with the offender as well to kind of tailor the agreement that comes from that. So I think it's a bit of I guess it's not the answer you're looking for, but.
I'm looking for an answer. I'm looking for information,
Yeah.
so that the information can be conveyed.
Clear.
They don't have to have all the answers.
Okay.
They just have to have enough to be
These are
knowledgeable.
examples.
Yeah.
Yeah. Okay. I guess, yeah, we can give you guys examples of what comes out.
One of the cases that I was dealing with on Tuesday involved a referral to integrated case management. A guy is a methadone baby, has some significant cognitive deficits as a result of it, is on the street. Send him to integrated case management so that they can get him started in some sort of secure housing. And because ultimately that's, in this instance, what was driving his conflict with the law. And so solving that problem was the focus of the contract ultimately.
I have to go, I'm sorry, I just want to make sure I understand, because this is, my understanding is that this was about the mediation aspect mainly. So are we doing it, are you guys doing it? I find it fantastic, by the way. I didn't mean to sound negative when I asked the question. I find it fantastic. I think it's amazing what you guys are doing. But I just want to make sure that I understand, are you doing it right now, or it's in preparation of, and we're gonna know when we can start moving forward towards, so that we, I don't.
With the John Howard Society, we're doing it right now.
Yeah,
Okay,
we
so
dealt
Yellow
with the
Knife
assault
is
with a weapon last night.
Okay, perfect. That's great. I think it's great.
Yeah.
Not just with that, but also a BB gun. So it was a pretty serious case, and I think it would have been a bit of a disaster being dealt with institutionally. The victim didn't really want to talk, and his mom said she didn't want to rat out her kids. It would have been a problem, but I think we were able to obtain an effective result by handling it the way we did.
And I know that it takes a different training when we're talking about sexual violence offenses. I have an interest in that a little bit. Are you looking into that? Are you there yet? Not there yet?
There isn't, this is the word I've been looking for all day, there is not a standardized training across Canada for mediation specifically to sexualized violence files. I personally, for the John Howard Society, I would be open to figuring that out. In terms of formal training, for sure, I would say we are looking at that. When that's gonna come, I'm not sure. Also keeping in mind that like committee members are volunteers. I mean,
Yeah.
FISA could get the training, yeah, I think with the sexualized violence cases, I think like Annie did previously, of reaching out to Kaitlyn directly, and or I would say the John Howard Society specifically, and talking about, like, what I would ask is, like, can we have a conversation? What is the file? What are the, like, Annie came in, kind of briefed us on the file, briefed where she was at with conversations with the victim, her understanding of the offender's willingness, openness to have a conversation. So that's what I would say. Like, personally, I'm ready to move forward with that in John Howard Society.
And there's no reason, as I say, that like anybody who the group agrees, and we would set this up in advance, can attend, a CWC or family member of your victim. The idea, as I say, is transparency, because that's ultimately what credibility depends on, and the idea is to make it work.
And do you meet the victim separately before?
Absolutely. Especially in a sexual violence situation, I would argue that we need to meet with them like multiple times to prepare to come together and make sure that like supports are in place.
So even for a regular diversion, the justice coordinator in any community should be reaching out offender first by themselves and the victim by themselves prior to ever continuing to go forward. So there should be somebody reaching out to each of those individually to go through the process, go through their concerns, see what they would like as generalized outcomes, see what has happened in the incident at both sides, and then they come together. So like there should be happening across the board in every community. Whether they're listening to that or not is another thing I'm working on, but it should be happening, and if you see it as a concern that the victim's not being reached out to, please do voice that to us.
An acceptance of responsibility is, I think, a critical part of the pieces on the checklist. So that has to involve prep with the offender in advance.
Also, something to remember is I know you gotta go in, but like our division, like we're community justice, our division also houses victim services. And I think you guys are quite used to working with, or your CWCs are, and you were quite used to working with victim services. Like really what I would like to see is a lot more collaboration, but our division houses community justice and victim services. So, and these are things that would need to be sussed out appropriately by a facilitator of like, who's going to be in the room, has victim services been engaged, have there been multiple prep conversations, these kinds of things. But in those situations, I think a victim services referral, if they're not already engaged with victim services would be essential.
I don't know if sexual violence is something that could be dealt with as quickly as other stuff, but it would be, because the criminal code requires the involvement of defense counsel, at least in terms of the signing off, if you will, the faster that can happen, the better. I wrote Santiago when I was going to be in court on Tuesday, saying, look, if you can give me stuff in advance, I can do intake for FISA this week and get stuff rolling. In the circuit, for the circuit communities, it's going to require that stuff get out faster so that defense counsel can meet with the accused at the circuit, and hopefully the Justice Committee coordinator can sit down as well at the same time and do that intake while court's still in town, so to speak.
I'm sorry, but thank you so much.
I had my opening comments prepared. I hadn't thought how to end it. I mean, as far as I'm concerned, as long as people have questions and want to engage in discussion and don't have to go to court, unless the room's booked, I have no problem carrying on. But
I have a meeting coming up, so I can't stay, but I mean, reach out to us. We're happy to meet.